Okay, we're on the record.
Mute yourself, Bob. Everyone was muted.
Okay. Adequate notice of this meeting was provided by the board secretary to the Daily Record and published on, you have a date there, or does it matter?
Yeah, October, I forget what date, but it was on
October 2021, stating the time, place, and date of all regularly scheduled meetings. A copy of this will be included with the minutes. This meeting is being held in accordance with NJSA 10:4-6. That's sec. Go for it, Nora. Roll.
Mr. Berkowitz,
Here.
Mr. Kaplan,
Here.
Mr. Mazzarella,
Here.
Mr. Parikh,
Here.
Mr. Reddy,
Present.
Ms. Snyder. Here. Mr. Willens,
Here.
Chairman Irakane.
Present.
We also have with us our board engineer, Mr. Holloway, our board
Here.
attorney, Mr. King, and I am not sure if our board planner is with us yet. Mr. Chadwick?
Present. Well, attorney's present.
Okay, this announcement is for the members of the public who have joined this meeting on their computer and selected to use the phone option for audio. If you dialed into the system using your phone, you will not be able to raise your hand to comment. To have the ability to raise your hand and comment, you must do the following. Leave the meeting, rejoin the meeting. When selecting audio, choose the option to have the system call you and input the phone number you wish to be called on. This option will pair your computer with your phone and will allow you to raise your hand if you wish to comment during the public session. Can't hear you, Bob.
Let's call case,
We have resolutions.
oh. I guess I should have printed an agenda. I'm sorry.
That's okay.
Can you carry the ball, Nora? I've
Okay,
been a little busy lately.
that's okay. All right. So application 2132, 2187, 2190, 2191, and 2183. I'll read who is able to vote. Jaskowitz not here. Kaplan, Parikh, Mazzarella, Reddy, and Willens.
I have a motion for those applications, those resolutions.
Yes.
So moved.
Second, any discussion? Nora, call the roll.
I'm sorry, who seconded?
Dave.
Thank you. Kaplan,
Yes.
Parikh,
Yes.
Mazzarella,
Yes.
Reddy,
Yes.
Willens.
Yes.
Okay, the next group of resolutions, 2175, 2167, 2192, 2188, 2195, and 21101. 21101, I just want to say was an application to withdraw. Those who can vote are Parikh, Mazzarella, Reddy, Snyder, Willens, Irakane.
Motion.
Motion.
Second, Snyder.
Thank you. Any discussion? Nora, call the roll.
Parikh,
Yes.
Mazzarella,
Yes.
Reddy,
Yes, except for the application 2192.
That's part of the package.
right, did you recuse yourself on that one?
Yes.
Okay. Irakane,
Yes.
You forgot
Reddy.
Snyder.
I'm sorry?
Yes, for Snyder.
Yes. Yes, Willens, Irakane.
Yes, yes.
Okay, and the last two, there's application 1940, which is an application to withdraw. In case you didn't look at it, it was the 1010 Vale Road, G Wang application, and then application 2153.
You know,
We ha-
Can
we
I,
have-
can I just make a comment on that 1010 Vale Road?
Mhm.
I think they removed all of the violations. I saw contractors there. So I think we may have shot ourselves in the foot because we never got the improvements that they would have done had we let them have the variance. So that's just my 2 cents. Take it for what it's worth. But, that was my fear. We wouldn't get the improvements that would help the neighbors. So that's it.
Okay,
Well, if there's still a problem with water to the neighbors, you can still go to the town engineer and get some, results that way.
he
Why?
sold his home.
Why? He withdrew his application. He doesn't need them. He doesn't need anybody anymore. He hasn't caused any problems. If you
Right, and
remove,
he's,
if you remove the violation, which I'm assuming he did.
Well, if there's problems, then there's other ways that the neighbors can go about it.
Mhm.
Sure, the neighbors can, yes. I just wonder sometimes when, we throw the baby out with the bathwater, and, if that's not a good analogy, I apologize, but that's the first one I thought of, so.
I agree with you, but we weren't dealing with a credible applicant either. He kept changing his story.
Oh, he
So
was a piece of
he
work,
was he was incredible, frankly. and
but his engineer was a man of high, moral. The engineer was somebody that I have used actually many years ago. He was good, so, and I was I thought that if he, look, it's water over the dam. Let's move on. We got other things to do tonight.
okay, so, those who can vote on these last two, Kaplan, Parikh, Reddy, Snyder, Willens, Irakane. You're muted, Bob.
I'm sorry.
Move.
Motion to, for those, applications.
So moved.
Do we move them both together or separately?
Take,
Because we're drawing one and the other's a D variance, so.
Do them separate.
okay,
Right,
Berkowitz made a motion. Who made a second?
Second, Snyder.
Okay, Berkowitz,
Yes.
Kaplan,
Yes.
Parikh,
Yes.
Reddy,
Yes.
Snyder,
Yes.
Willens,
Yes.
Irakane.
Yes.
And then the last application, 2153 Araya Village, Berkowitz, Kaplan, Parikh, Reddy, Snyder, Willens, Irakane.
Move Berkowitz.
Second ready.
Thank you. Any discussion or call the roll?
Berkowitz,
Yes.
Kaplan,
Yes.
Parikh,
Yes.
Reddy,
Yes.
Snyder,
Yes.
Willens,
Yes.
Irakane.
Yes.
And I just want to say quickly that Mr. Chadwick is working to get online here with us.
Okay. So let's call the application of the night.
Do we have to do the
I'm sorry.
postponements on the other cases?
I'm sorry, we have one more thing to do. We have applications from our last meeting that was canceled. Application 21105, 2196, 21103, 2198, 2199, 21100, 21104 were all carried from March 9th without further notice and with any required extensions carried to tonight for announcement of the April 13th, 2022 hearing date.
A motion to that effect?
So move, Snyder.
Second Willens.
Thank you. Any discussion? All in favor?
Aye.
Aye.
Anyone opposed? Anything else, Nora?
Nope, I'll stop interrupting.
Let's call the next case then.
That would be GP acquisitions. Bob, you're muted again.
I had audio. It was just very faint.
Mr. Vogel?
I'm here. Are you ready for us?
Yes,
Oh,
we called the case. I'm sorry.
I'm sorry. I didn't realize you called the case by name. I thought you were referring to other matters you had on the agenda. Good. Good evening. Thank you for having us back. We previously submitted testimony with respect to the site, which included both the operator and the proposed contractor. We've defined the use for you. We've had the engineer testify with respect to the site. We've had the architect describe the structures, and we've had a traffic engineer describe the flow of the traffic. Our remaining witness is John McDonough, who will testify with respect to the planning aspects. And unless there's a question of me, I would call Mr. McDonough as our witness.
Sir, could you raise your right hand? Do you swear affirm the testimony you're about to give before the board is true, so help you God?
Yes, I do.
And all your licenses are in full force and effect?
Yes, for the record, my license is professional planning on the New Jersey level and AICP on the national level.
And you've been qualified before this board and other boards in the state of New Jersey?
Yes, I have.
Mr. Chairman, he has been qualified as an expert in planning.
Thank Mr. you. Chairman, just point, Ms. Vogel, pardon the interruption, but just a point of order here, and Mr. King, maybe you can help, but when we last left, Mr. Vogel had a witness up that had extensive cross-examination or questions from opposing attorney. There were a lot of people in the audience that never had an opportunity to ask questions of that witness at that time. Is that inappropriate, or will they have a opportunity to question that witness at a later date?
They have the opportunity to cross-examine that witness. So if that witness was here, he should be presented so that members of the public can cross-examine as well as the opposing attorney. It's my, I thought
If I recall, the opposing attorney asked all the questions, and there was a lot of people there present that never got a chance to ask the witness any questions. Oh, my notes don't reflect that there was remaining cross-examination. That may be true. Which witness is it that you've said did not have complete cross-examination?
That would probably be Nick Verderies, the traffic engineer.
Yeah. Your last witness.
Counsel, do you have him here, or do you want to present another witness and bring him back so that members of the public can...
Well, Mr. Verderies is here, is he not?
Yes, I am.
We'll hold Mr. McDonough and let you complete whatever cross-examination you have in that regard. I don't know, Mr. Vogel, if there is any, but I do know that the people in the public that were there had no opportunity to ask any questions. Well, I certainly don't want to create an issue that someone didn't have their right to cross-examination. So I have the witness here.
So Mr. Vogel, you'll call that you'll call your traffic expert as the witness, and Chairman, if you could open the meeting to the public for any questions of the witness at this time.
At this point, does any member of the public have any questions of the applicant's witness? This is the time to ask questions only. This is not the time to testify. So Nora will tell you how you can go about raising your hand and how you will be acknowledged. Okay?
So everyone has, down in the lower right-hand corner is a little raise hand icon. You could click on that. Okay, and we do have Nick Homyak. If we can unmute him.
Sir, for the record, could you state your name and address?
Can we unmute Nick?
Nick, you can go. You're unmuted.
It's showing that he's muted. There you go.
Name and address, please.
26 Oneida Avenue, Lake Hiawatha.
Thank you.
Uh,
Oh, please.
In
I
order
want
to,
see the-
in order to accommodate this development, how much additional impervious surface will be inflicted on this landscape for ingress and regress?
That was not the subject matter of Mr. Vertisers's testimony.
It's traffic, is it not?
Yes, it's traffic.
All right, so how is any traffic accumulating from your site will affect the traffic coming in and off your proposed development?
That's a different question. That's a fine. Mr. Vertisers, answer the question.
Sure. It kind of sounds like maybe you weren't at the last meeting, but I'll give a quick little summary. So our proposal is to actually modify the driveways to switch the ingress and egress. So currently today, you ingress at the north and egress at the south. We will be reversing that, but there will be no additional impervious associated with that. It would just be signage and striping.
The public's asking the traffic guy from last time questions. They never got a chance to. It was late.
All right. I must have missed it or forgot because it's been so long.
Are there any other, is there anyone else who would like to question the witness? I see no hands raised.
Counsel, do you want to call your next witness, which is, we've sworn already?
All right, so we're clear on the record that there was an opportunity given to cross-examine Mr. Vertisers. Just want to be clear about that because I don't want the issue to come up later and be an issue raised by anyone. So we're clear, Mr. Chairman, that Mr. Vertisers is here, available to be cross-examined, and the public has been given the opportunity to do that, and there are no further questions.
Agreed.
Thank you. May I believe before we interrupted to have the question of Mr. Vertisers, Mr. McDonough was sworn. Mr. McDonough, you understand you're under oath, are you not?
Yes, I do.
And Mr.
All right.
Vogel, he was also qualified, so he is qualified and sworn as an expert.
Thank you. Mr. McDonough, at the request of the applicant, did you undertake to do an examination and study within the context of your expertise?
Yes, I was, and yes, I did.
All right. Would you describe to the board the process that you went through and the conclusions that you reached?
Sure thing. We conducted a standard planning analysis as we do typically here in the community. Basically 4 parts. We reviewed existing conditions, proposed conditions, the zoning that's relevant to this particular piece of land. And of course, our applicant is here asking the board to move on relief, which is certainly allowable within the statute and provable subject to the meeting of certain statutory criteria, which based on the evidence on the record, the abundance of evidence on the record through a number of witnesses before me, I think there is substantial credible evidence on the record where the board could move favorably on the application based on meeting the statutory test. So that was our analysis, Jerry. Keep rolling.
Yeah, would you go through go through what it is that you did to make your analysis and the conclusion that you reached.
Okay. If I could ask, Mr. Chairman, Nora, can I have opportunity to share screen here? Because I think the site does a lot of the talking for itself.
You can share.
Okay, so here is our site. It is a single tax lot. And by the way, do we need to mark this as an exhibit? It's going to be a series of maps and a plan, the variance plan that's been submitted as part of the variance application. It's 5 parts, 5 pages, 5 slides. I don't know, Counselor, if we prefer to mark them individually or as one bundle.
Mr. King?
I mean, this is a colored map. I know that you do have some colored exhibits, but I don't believe this was, provided as part of the packet. So I would mark each individual one just because of the size and scope of this application.
Okay. And Mr. King, can I ask where we left off?
Who's he? The planner. He's pretty good.
Their planner?
Yeah, he's pretty good.
May I suggest that
How do you know
we mark it A1 with today's date? Does that work?
So for the record, we're going to say A1 3/23/22.
Very commonly area.
Correct.
Okay, so we'll start with the very simple. We'll work up to some more detail here. The board's had a lot of evidence now by qualified experts, sworn under oath to tell the truth. We'll get into the positives and the negatives shortly, but it all starts with the land. We've got a substantial piece of property here from an area standpoint, from a geometry standpoint. You certainly can see it here in comparison to the context of this area, which is sitting on a very similar landform as what's proposed here. 22 acres of land, and the applicant is looking to develop approximately half of it. Approximately half has already been developed, and half remains. This parcel of land that you see in the back, lot 166, I'm sorry, block 166, lot 83, Far Hills High School. I know it well because I went there. And this is what the development pattern looks like in the area. So we've got St. Christopher's Church on the front of the property. Again, 22 acres. So after subdivision to effectuate this senior living facility, we're looking at about 12 in the back, about 10 in the front for St. Christopher's, which has never needed this land. I think we all know that development of this parcel is inevitable. I go back to the 1970s, pitching on that mound there until a guy named Joe Orsolak came along and bumped me off the team and went to the Mets. This piece of land has remained undeveloped, but it is now, I think, inevitable that it will be developed as the church is looking to rid of this excess land that it doesn't need. So clearly, we are here in an area that has been substantially built out with smaller scale homes. At one point, this was all forest here. So again, trees need to come down to effectuate development, and any use of this parcel would result in removal of trees. That's just the nature of the area. That's just the nature of development. And then we got the high school here, which importantly, this development is adjoining not the core or the academic core of the school, but more of the service area of the school as you come in off of Rita Drive. You got some maintenance buildings. You see some stockpiles out there in the winter for sand and snow removal, salt and the like. And then you work your way over to the academic core. And then, of course, the ball fields in the back. We've got some good buffering here. The institutional use in the front. And interestingly, you see the color coding here in red. That indicates institutional uses. Gold are your residential uses and green are your undeveloped land. So importantly, this land use as an institutional land use is a bridge between two other institutional uses. So we've got good continuity here from a land use standpoint in terms of what the applicant is proposing. The way the site has been zoned, much like the school, this patch of land here is in the R1 residential district. And as you can see, most of those properties there to the west are in that R1 zone as well. As we work our way over to Rita to the south and then out to Littleton, we're looking more at the R3 uses. So the church kind of straddles the line between the R1 and the R3. And then again, of course, we got some tighter density with the R3 over at Rita, and then working our way back to the north of less density. So the plan that's before the board is well familiar to the board now, and you've heard the analytics, you've heard the operational testimony. We're looking at 156 units here. 50 units are going to be those walking cottages, which is the lesser density that you see closer to the residential homes in the church. And then we start to work our way back to the more compact development, I'll say, where we include those all-important memory care units, and then the combination of assisted living and independent living as well. Total of 156 units here, and you've got good operational testimony on the record as to why here. Integration is key to the nature of the use. Integrating what will be this person's home address. This is their residence. This is their primary residence in a residential area. So again, we're looking to integrate these residences within a residential area, as opposed to some of your commercialized areas. You do allow this zone in your COD district. You allow it in the OLV district, and you also allow it in the office service district as well. Again, predominantly office-related uses, but you heard here that the spirit of the application is integration with residential of all different demographics and age cohort. So with that said, in our report, we gave you a little breakdown of the amenities that the applicant is proposing here. You've got a social court, fitness center, cafe, open workspace, outdoor recreation areas, hard and softscape landscaping, the walking area, and again, the combination of cottages, smaller scale residential, and then larger scale residential as well. Additional amenities include that medication management, nursing assessments, fall monitoring, oxygen storage, healthcare service coordination with hospice and home health, on-site pharmacy, delivery coordination, occupational therapy services, speech therapy services, physical therapy services, on-site podiatry, accessibility, and biohazard waste coordination. So all of those benefits are cooked into this particular land use here. Now, all importantly, again, we are in the R1 zone district where this particular land use is not permitted.
Council,
So
do you want to mark this exhibit?
Sure. And I think maybe for the record, I'll just go through.
Mark, there was A1, which we marked. Then
A2 is going to be an aerial photograph.
right, the aerial photo would be A2.
And then A3 is going to be a land use map. This is based on our Mod 4 land use classification system that again characterizes land uses based on residential, institutional, vacant land, commercial land, and the like.
A4, and then A4 is another zoning map colored,
That's correct.
and then A5 is the variance plan.
A5 is your variance plan, correct. So again, this is the build out that the applicant is proposing here. You've gone through a good sequence of witnesses to walk you through the operational aspects. Back on August 18th, that was actually back on June 16th, and then on August 18th.
You don't think so? Why?
I don't see on there.
Can we mute, please, our computers? We're hearing ongoing conversations. Thank you.
Thank you, Ms. Snyder. I didn't know if that was directed at me. So June 16th and August 18th, we heard from our operator, Les Stress. We heard operational testimony before that as well. Then we heard from Mike Testoris on October 13th with respect to how the whole site integrates, flows, functions, operates. And then, of course, we heard from Nick Verderies back on December 8th with respect to traffic and his conclusion that this is going to improve traffic conditions, improve circulation, and result in a net traffic safety benefit here. We all know what Littleton Road is like. We know what Rita Drive is like. It's taken those lefts out many times. So improved traffic safety and circulation is at the heart of any land use application. And you've got good, solid testimony here, uncontroverted expert testimony that this site will flow, function, and operate safely and efficiently. And that's important because flipping back to the zone that we're in the R1 zone district, where, as I said, this particular land use, senior living facility, is not expressly permitted in the zone. You have assisted living facilities that are allowed in some of your office zones as well. So what we did in our report, we walk you through the statutory test that would apply here. And we're looking at a distinct land use. We call it out as inherently beneficial. We gave the board some court cases where it has been found to be inherently beneficial, and they're referenced in the report. Planning operates within a legal framework. I'm not the lawyer. I'm not pretending to be, but I've heard this many times, reference to the Sunrise case over in Madison, the Borough of Roselle case. We put these in the reports as well, and then there's a case out of Patterson as well. That's the law. We'll let the lawyers deal with that on closing, but I can also tell you that I have testified here for this land use in Parsippany before, where it was determined and interpreted to be an inherently beneficial use. I testified for that Care One facility back in 2005, then back again in 2012. I think we all know that facility there. I've experienced it firsthand with families and with my family, I should say. And I've been here in front of this board testifying on that. And that particular facility we know is packed. We heard about waiting lists. We heard about intensity of demand. There was expansion over there. There was density relief that was granted over there. There was additional parking that they were able to find because that was a site that did have a shortage of parking. And the key point there with respect to that particular application was, again, it's right here in Parsippany. It's the exact same land use with a combination of independent living units and assisted living units as well. And of course, the dementia and the memory care aspect as well. So you've got good local finding in that regard. Very important here because that defines the test that we're looking at. And usually when I talk about the SECA test here in front of the zoning board, we're dealing with maybe inherently beneficial uses or childcare uses. I think this board well knows that our statute defines inherently beneficial uses as that narrow band of uses that are sort of the cream of the crop from a land use perspective. Churches, schools, hospitals, healthcare facilities, those type of things, childcare, are at the top of the land use spectrum. And the finding is in the land use law and in the legislation and in the courts is that inherently beneficial uses automatically serve the public good. We often go through the positive criteria and the negative criteria. My testimony tonight on direct is going to be somewhat short because the courts refer to this as an analytic shortcut. We don't have to satisfy the positive criteria. There have been very good questions by this board, as there always are, and the public as well, as to need and unmet need and demand. And I know Mr. Stretch was getting hit hard on this in terms of the why here question. It's not the applicant's burden under the law to answer that question. It's echoed in your master plan that there is an aging population here in the community and a need to plan for appropriate type of housing and appropriate locations. But when we're dealing with an inherently beneficial use, again, it is not incumbent upon an applicant to demonstrate need. So we don't have to demonstrate, or I should say the applicant does not have to demonstrate any market analysis in terms of the aging of the population here in the community, but there's certainly recognition in your master plan. Also importantly, whenever we're dealing with the Medici test, which is a much more enhanced burden on an applicant, we look at site suitability, and an applicant has to talk about how well the site is particularly suited for the land use before you. Again, that's a given here when we're dealing with an inherently beneficial use. So what does the test apply here? It is a simplified 4-part test. We call it the Sika test because it was named after a court case that involved a gentleman named Dr. Sika, who was denied an application to have a head trauma facility for patients that suffered head trauma in a residential zone. It was denied, and it made its way all the way to through the court system, where the court said, again, those enhanced burdens of proof are not incumbent of an applicant, and whenever we're dealing with inherently beneficial, the positive criteria are automatically satisfied. The burden, of course, then shifts to the negative criteria. There's nothing about this land use being inherently beneficial that means it gets a free pass. And the board has done what the board does very well. And I'll say kudos to the public as well for asking all the right questions. I listed about, as I went back and listened to the tapes, I listed about 25 potentially adverse impacts here that were raised as concerns by the board, by the public, by applicants, objectors counsel as well. I wrote them down, and as I sit before you now, none of these impacts are left unresolved, unmitigated, unanswered by the witnesses that have gone before me. And so we'll go through that as we go through the second part of the test. So let's take you through the 4 parts. Part number 1 of the Sika test is to identify the public interest at stake. I'm going to stop share here just so we can actually see me testify. Public interest at stake, we put it in the report here, is housing and services to meet senior citizens. This has been found as a need, I'll say, or of paramount public interest in your 2014 master plan. And then you've come out with a fresh new master plan as well that doesn't contradict any of the things that we put in the report here. The master plans recognize the importance of planning for the demands of an aging population. And we know in the municipal land use law, there are about 18 or so purposes of zoning that give your town the right to zone and establish districts in the first place and establish a zoning board in the first place. One of those core purposes, Purpose L, is the goal to plan for and provide for senior housing, which is exactly what this applicant does. It's a specialized type of housing. And so I think we can turn to both the statute and your master plan. The master plan does say there was significant growth in the 55 years and over population in Parsippany Troy Hills, the 55 to 64 category, the new wave of empty nesters, and this was 2014. It's talked again about in 2020. In fact, the 50 plus cohort is the largest cohort that you have here in the community. We all know Parsippany is a great place to live. It's in all the magazines, and I think the reflection of the aging of the population is reflective of that it is a good, healthy environment to live in. So we see a 30% increase in the population from the, I think it's the 54 to 64 category. So again, significant increase in the percentage of persons that are aging in the community. It says here in the master plan, as this growing population segment ages, the township will have to address the growing demands for services tailored towards seniors and those approaching senior citizen status. It recognizes that more than 1 out of every 4 Parsippany Troy Hills residents is 55 or over. And it says here, a range of housing options exist in the township. The range of housing alternatives vary from multifamily attached apartments to single family homes on large lots. this diversity of housing stock, which is a primary goal of planning, to provide for a diversity of housing options according to the needs of all people, serves different segments of the population, and due to the aging of the population, housing options have become particularly relevant. I'll also refer to the board to the Fair Housing Act, our federal law, which requires land use board to make, quote, reasonable accommodations to accommodate handicapped persons to live in neighborhoods of choice. Memory care and assisted living residents have been found to be handicapped under the act. So again, this caters to persons that are qualified under fair housing as being handicapped. So again, we've got the independent living, the sequential living, and then the assisted living, and of course the memory care, all integrated here to create an inherently beneficial use that advances both the federal aspect, the state levels, and the local levels as well. Now, the second part of the test looks at what the board has really been doing for the last 5 or so hearings. Identify the potential detrimental effects that could ensue from the grant of variances. You have a variance plan here, which is not 1 page, but it's actually 9 or so pages, which is unusual from a planning standpoint. We don't see a variance application have that many plans associated with it typically. Notwithstanding, the board can certainly condition any approval here that any subsequent site plan is in substantial conformance with that variance plan, which is representative, illustrative, obviously subject to refinement here, but it gives the board a good sense of where this use would go if the board were to grant it. So I think that variance plan was critical to show that this is a site that has been well planned, well integrated with these mix of uses, sensitive to the surrounding neighborhoods. You've got some good buffering here. The plan has evolved through the process, and I heard our engineer talk about, in particular, increasing the buffer to the south. I heard 20 feet being offered as opposed to 10 feet on the plan now. That would go towards those homes on the Reeder Drive side, on the southern side. The development is well planned with respect to vehicular, pedestrian circulation, stormwater management, solid waste management, utility demand, building codes, fire codes, lighting design, landscape design, and as we just said, buffering. Now, with respect to impacts, any development is going to have impact. This is a site that is not zoned for park. It is zoned for development. I think our engineer said 16 houses could go here. I tend to lean more with Mr. Chadwick that that's probably north of what the yield would be here. Again, on a 12-acre site with approximately 1 acre zoning, let's say 10 to 12 units here. Again, one of the nice things about this application is that it does have a level of certainty to it. What you see is what you get. It's not necessarily a guarantee with residential uses. This board hears a lot of homeowner applications, amenities in the backyard, pools and the like. So single family residential is not a utopia in terms of impacts on adjacent residential uses. So we have to give deference to the fact that this land can be developed for single family residential use. Interestingly, your code also has another land use that could go here on sites that are over 5 acres. Now, this is an agricultural use, but it does talk about, it's in the zone plan, building used for horticultural, agricultural, dairying purposes, and then the parade of animals, poultry, cows, calves. This may well be old zoning here, but it's still here. So we know there can be impacts associated with that land use as well. We know this is sort of I'll say a hole in the donut application. This is the last remnant piece to be developed in this fully developed area. So I know we have public here watching and listening, but again, there will be impact as this property eventually develops. And we do have to look at the degree of departure from what's contemplated in the zone scheme. I know there are more units contemplated here, than the 10 to 12 single-family houses. But again, I think we have good testimony on the record that the site can accommodate that, certainly from a technical standpoint. And you have good, strong testimony from Mr. Stretch that from an operational standpoint, they have a good handle on what they're going to be doing here. So again, based on the extensive, well-vetted testimony on the record here, I think all of the potentially negative impacts that would ensue from a grant of a variance here have been addressed from a use standpoint, bearing in mind there are 2 layers to this application. If the board does grant the use, you still have to get through site plan. And that doesn't mean we're trying to bypass the use here, but I think there's substantial credible evidence here to move favorably on the use. The 25 things that I wrote down, I'll go through them very quickly. Traffic, Mr. Verderes talked about traffic improvement. Tree removal, number 2. And I'm kind of starting from what I wrote down as public and board made comments along the way. Tree removal is inevitable here. Something is going to go here. I heard concern about neighborhood character as well. Again, this is integration of what is really people's homes, people's housing integrated within a residential neighborhood. It is clearly a different form of development, but we think that it has been well designed, well planned to integrate well to the surrounding neighborhood. As you heard through Mr. Textoris, the buffering here, the building heights in certain respects are going to be lower than what could be. So the impacts from a bulk and a mass standpoint, again, we always look at a qualitative analysis, not a quantitative analysis. So just because there are more units here does not mean from a qualitative standpoint it is going to erode the character of the area. I wrote down number 4. Again, I was just taking notes here. There was a concern about eviction. I think the answer is that'll be done in accordance with the law. I think that's the short answer there. Just as any apartment would be evicted or in any home if a person is acting improperly. Number 5 was concerns about public health. I think that was all vetted by Mr. Stretch as well, particularly with respect to, I think, what I have down as number 6, the security and protecting the pharmacy aspect and the double lock with respect to the narcotics. So I think both public health and security have been addressed here. There was concern, number 7, I wrote down about transport and community impact. And I think you heard through Mr. Stretch that the intent here is that this is not going to burden the ambulatory system here in the community, that they will work with independent, or if an agreement is worked out with the community, I don't think they want to foreclose that option also. There was number 8, there was a concern about animals. I don't know that that was a concern per se, but animals could certainly go here. They could go here if there were single family uses as well. Number 9 was concerned about children being here. Again, it is a site that is zoned for children. 4 5-bedroom homes would certainly attract children here. And you'll see when we get to part 3, which is a very important part of the test, is whether the board can impose reasonable restrictions. It's sort of unique to the SECA test that it's specifically in there that the board can impose reasonable conditions with respect to ameliorating any potentially detrimental effects. Again, this could be a back and forth with the applicant, but restrictions on children, and I understand that there's restrictions under the law anyhow. I'm not going to touch it, but I don't think that a child under 18 can live here, but I'll let the law guide that. Number 10 was concern about a restaurant here and some fine dining. We talked about the fact that what I like about this application is that there is an unbundling component, that there is an opportunity for integration with the general public and with the applicant, with the residents here, which I think is a good thing. I don't think that's a bad thing. You heard Mr. Stretch talk about how this will certainly be monitored. And I think that's just another reasonable condition that can be discussed with the board. Obviously, we're not looking to change this site into Buffalo Wild Wings, where everybody is coming here on a Sunday for the football game. I think this is a different animal, if you will. There was, number 11 was a concern about alcohol being offered here, but again, I think with reasonable restrictions, it's no different than what we would see in a single-family neighborhood. Number 12, there was concern about property values. I'm not a real estate expert, so I can't touch that, but I have not heard any real estate say that this is going to cause a drop in property values. And I personally don't know or have heard of any correlation between this land use and a degradation of residential property values. 13 was a concern about odors being generated here. And again, this will be a kitchen that does provide the appropriate ventilation for whatever the local health code would require. Number 14, I wrote down tax relief, and I think that question was, is this going to generate revenue for the municipality? And the answer is yes, it is a taxable business in the community. I think that's what the question was. Number 15 was a question about alternate sites. I think the board well knows, yes, you do have other zones that would allow for this land use, but I think this board also well knows that we have the Supreme Court in New Jersey, the Price-Amidji case, which says availability of alternate sites is not a basis for denial of a use variance application. So again, I'll let the law speak for the law. Number 16 was concern about road maintenance and who would have the obligation. And to my understanding, this is going to be privately maintained. I'll say third party or operated by the operator. I don't think there's a municipal obligation here, but I guess that's something that could be vented as well. 17 was, you heard that the site does flow from the baseball fields down to Littleton. Concerns about off-site impact from a runoff standpoint. And again, the testimony from the engineer is a level of confidence that the stormwater system will meet all acceptable codes. That will play out as we go through the stormwater management design. And you've got a good qualified engineer there who will certainly be the safeguard on the city side, on the municipal side, to make sure that that holds. Number 18 is visual impact. You have cross sections that were put forth by the applicant with respect to the lower profile of these buildings, those slices through the site that Mr. Texturis talked about. Number 19 was with respect to brightness and illumination. Yes, we do have parking lots here. The brightness levels will be in accordance with the municipal regulations in terms of off-site spillage and glare and the like. Dark sky compliant, not creating a glow, downward directional lighting. Not to mention we got ball fields right up on the hill, the football field and the like. So there is some ambient influence on the area as well. Number 20 was a concern raised by someone that this was a concept plan. It's not a concept plan. It is a variance plan. There is a level of detail that goes into this. And again, what I typically see in use variance applications is a condition that any subsequent site plan application needs to be in substantial conformance with the variance plan. If it is a radical departure, of course, it would have to come back to this board for, I think, amended use variance approval for sure. 21 was concerns about density. The density here, I think we landed at about 13 units per acre. The density over in the COD zone, where this land use is allowed as a permitted conditional use, allows for 17 units an acre. And by the way, where this is a permitted conditional use, this application stacks up with all of those conditions if this were in the COD zone. So I think you can take some good guidance there in terms of how this would stack up with the minimum lot area for assisted living, 6 acres. We've got 12 acres, so we've got double that. The buffers, the setback, the coverage, the density, the height, all comply with what you would see for this land use over in the COD zone. So I think the form of development here, the intensity of the development is on par with this particular land use. We often hear when we're dealing with use applications, the Paleo case talks about the separation of C and D variances, and I think the board can consider all of those elements as part of the overall use variance application. Number 22 was a question whether these are the outside agencies, the RSIS would apply here. And I believe the engineer addressed in the affirmative that it would comply and conform. And then finally, with respect to Highlands, I think the testimony as well, as I went back and listened, is that obviously this is going to be subject to outside agency jurisdiction, and that a certificate of exemption would be required here. I think that came through Mr. Chadwick. I said 25 things. I may have missed them, but there's 23. Part 3 of the test takes those potentially negative effects. And again, is the part that says the board can consider whether the imposition of reasonable conditions would ameliorate any detrimental effects. In my experience in these SECA applications, that's a big part of the back and forth, and that may be what's coming next. And then finally, is the balancing. This is a balancing application, taking the weight of the positive, this substantially important land use. I'm sure it's touched most of us on this call here. There is a need to plan for this, unfortunately. And this is a good spot for this based on all of the reasons that the applicant has put forth on the record. I will point out that not only do we have the inherently beneficial aspect of assisted living, you heard about affordable housing as well, and this is going to provide for a 20% set aside here as well. Again, going to that planning goal to plan for everyone, people of different income levels. And then finally, there is an aspect of the church to this as well, which is yet another inherently beneficial use. The church is party to this application to the extent that they are agreeing to the application and allowing the application. So with that, I think there's more weight that starts to pile on in terms of the overwhelming positives of this application. That said, I think on balancing, if we take that heavy weight of the positive, the mitigated weight on the negative side, I think there is, again, substantial credible evidence on the record here for the board to move favorably on this application. The statutory test is met. The board has done a good job, as it always does. I think the public raised good questions here. And with that, I think I'm ready to stop. Jerry, I don't know if you have anything on redirect or.
John, I have a question with regard to the fair share housing. Is there an allocation for this development that would benefit the town's obligation?
Well, the stipulation on the record was the 20% set aside, and 2025 is coming right around the corner. That's our next round. So this obligation that's hitting all of these towns hard is coming around again.
Can we clarify that 20%, is it for all the units?
Jerry, I'm going to defer on that or less in terms of its, I don't want to stipulate for the applicant, but 20% is what I heard at the outset.
So the simple matter of fact is whatever the requirement is with respect to any of the units concerning affordable housing, this project will provide its quotient. That's all. We've done it in other projects, and there will be some affordable credits for the municipality. That's clear. What that number is will be determined upon whatever the law requires.
It's not a number, it's a percentile. That was a simple question.
I'm sorry, John, what was that?
It's are we doing 20% of all of the units?
20% of all of the units? No.
Yes. Okay. What 20% are going to be done?
Whatever the law requires, John. I haven't gone through that.
there's this use variance.
Law requires 20% of all the units, it'll be 20% of all the units. If the
Okay.
law requires 20% of one part of the units, then it won't be, but you'll get your quotient out of it.
Okay, the township's ordinance as a result of its settlement with various parties is 20%, period.
Yeah.
It's the law. I just wanted to clarify it because I've asked this question probably in 5 different hearings. I think we've got it clarified.
John, I think you also asked about allocation for water. Do we have water for the project?
I did.
Did you get a response or answer?
Well, with respect to
I think
water,
Mr. Vogel responded. He said, when we get it, we get it.
water is a function of site plan approval. This is a use variance. The use variance does not include site plan. When we come before site plan, we have to prove all the existing utilities are available. If they are not, then we can't build it.
No, I understand that, but I just was wondering if you had answered the question.
I disagree with Mr. Vogel. I think a use variance has to show the feasibility of it. If I got a piece of land that I have no access to, and I want to make a proposal, I've got to show how I'm going to get to it. Well, same thing with water and sewer. And we know that water is a critical issue. I thought your answer previously, Mr. Vogel, was if we have to wait for it, we have to wait for it. Am I wrong?
I think that was, the answer, John. Yes.
I just have one other quick question to John McDonough.
Yep.
Are you contending that this entire project is inherently beneficial, that I'm focusing on the cottages?
Yes.
Is this at the outset, and it seems to be that the case law is not consistent as to senior housing being inherently beneficial. They're starting to break it down and break it down and break it down. High-end adult communities, they're saying, are not inherently beneficial. Although Seeker simply says senior house.
Yeah, well, all I can say is, having lived over the Care One application on multiple occasions, that has a combination of independent living and assisted living, and memory care. There are a lot of parallels in terms of the unit mix. Now, that development is on an island, so it's certainly compact, but the finding there was inherently beneficial.
I'm sorry to interrupt. Let the board members go ahead.
I have no further questions of the witness and submit it for any examination the board or the public may have.
Any members of the board have any questions of this witness on the testimony given this evening? Mr. Chadwick, Mr. Holloway, somebody want to chime in? No questions? Can you guys hear me?
Yeah, the only question I have is, we're just considering a D variance. Any C variances we deal with at site plan if we have it. Is that true?
Yes.
Well, I guess,
I have a question.
yes.
Okay, John, you said that somehow the St. Christopher's Church is part of a inherently beneficial use? I mean, what was that about? Can you explain to us?
Yes, and thank you for the clarification, Mr. Parikh. I am not I am not trying to, I'll say pull a fast one and say that's, all I'm saying is the church is also involved in this, is a beneficiary of this application. They are looking to get rid of that land in the back. So the board can give it the weight it gives it. I would offer its low weight, but I just do think it's worth mentioning that there's also an inherently beneficial use that is, co-applicant is probably the wrong word, but consenting to this application. It's their land.
Yeah, I think it was a stretch because you are saying that because church was the beneficiary of this development, because they wanted to sell this property, you are saying, you are connecting it to inherently beneficial use. And I think that is a
I'm with
stretch.
you. And I will certainly recede on the fact that I'm saying it's extra inherently it's an inherently beneficial use in and of itself.
Is there any negative impact on the neighbors on the north and south? I mean, you talked a lot about the benefits. Is there any negative impact to the north and neighbors residents on the north and south?
Well, there will be the usual impacts that any development brings. It's inevitable, but we always look to see if those impacts are going to be substantial. Obviously, during construction, there will be impacts there in terms of noise and the like. Once the development is built and grows up, we are going to have a nice green edge around this property, more robust than what you would see with single-family development. So that will enhance the privacy use, the enjoyment of those residential uses. You don't get the same buffering with a single family. I'll call them large estate lots. This is large lot zoning over here. And I'm not aware of a buffer requirement being required for those homes against similar sized lots.
And my next question is, you compared Care One facility with this one. You say similar, not only use wise, but otherwise you kind of compared Care One a few times during your presentation. Is the site of Care One and this one is similar or comparable to the site location?
Well, Care One, as I said, it's an interesting site. It's sort of a football-shaped site in an island over there at Mazda Brook, which is a planned development, a planned community that has housing, that has a mix of uses there. You've got non-residential as well. So, if the question is the site similar? No, the sites are different. But all I was trying to say was how the use category was handled by this board in the past. That was what I was saying, substantial.
Yeah, because I was just thinking about both the sites. The Care One facility, just one side there is a residential, but three other sides there's no residential. While this side has a residential on two sides, and also there is a school there. So it's much more than, and on the opposite side too. So it's much more residential, surrounded by residential than a Care One site. That's all I just wanted to know.
Right, and as I said, my understanding is that these units are these individuals' primary residence. These are their homes. These are where they live. So I think it's not a bad thing that we're putting people's homes next to people's homes. It's a different form. There's no doubt about it.
And the last question I have is about the impact of having a 10 to 12 single family homes compared to what we are proposing here. I mean, what do you see the difference between the two as far as impact is concerned?
Well, from a land disturbance standpoint, there's a lot of...
No, for the neighborhood, for the traffic, for the water and sewer, tree removal, emergency services, everything.
Well, I have to rely upon the experts that have gone before me that there will not be substantially adverse impacts from a traffic generation standpoint in terms of water utility demand. And I mean, that's all part of the negative criteria for sure. And these are sworn experts that have gone before me. So I'm not going to question them.
I understand. You did mention about all this impact about emergency and sewer and water and other things. So that's why I'm asking you the question. Is 10 to 12 single-family homes has the same impact or similar impact as, I don't know the total number right now, but number of units you are going to have here?
From a purely physical standpoint, I'm not convinced that the development footprint of a single-family neighborhood, and by development footprint, I mean the disturbance, would be less than what the applicant is proposing here. That's from a pure physical standpoint. And then, of course, there's the impact, the intensity impacts, which again, I have to fall back on the experts before me in terms of demand on community services, demand on utilities, and your road network.
All right, thank you.
Welcome.
Any other board members have a question? Before we begin the public, let's take a 5-minute break, okay? 5 minutes, just 5 minutes, guys, okay?
We ready?
Everybody ready?
Yep. Yes.
Set.
Nora, are you there? Nora?
I'm here. Oop.
Okay, good. Peter, are you here? I don't see Peter, are you here?
I'm here.
Okay, good. Let's get rolling. So, at this point, we're going to open it up to members of the public who might have questions of Mr. McDonough on testimony given this evening, and I'm going to emphasize the questions will be on the testimony given this evening. This is not an opportunity to testify. This is an opportunity to ask Mr. McDonough questions. And please keep your questions in line with what his testimony is. This is what he's going to answer questions about. He's not going to answer questions about issues that may have been presented by another witness. So I hope members of the public are listening, and Nora, take it away, okay?
Okay, before I do, Mr. Bryce, the attorney, for the group opposed, and we're going to take the public first, correct?
Mr. King, what do you want to do?
I would take the attorney first because he represents a number of the public. And the public should understand that if they're being represented by Mr. Bryce, then unfortunately they can't ask questions separate from him. He represents them, so he will ask the questions for them. And anyone who's not represented by him on the list that we have, then they can ask the questions. Mr. Bryce, the list that you provided, is that still accurate?
He just disappeared.
So we just have to verify that list. He may have had some other people join, and if that's the case, we just need an updated list. He should be providing that to us before every meeting.
I think he did provide us, right, Nora? Didn't you send me a
It's
copy
the-
of a letter?
It's the original list. Nothing
Oh.
has changed.
Okay.
Yeah, Mr. King, I have that list. That list is the most updated list that was provided.
So you can ask the questions first, and possibly some of the questions you ask will answer some of the non people out there's questions. So we'll let you go first, okay?
Thank you. I appreciate it. Thank you, Chair, Mr. King, and the rest of the board. Mr. McDonough, how are you tonight?
I'm good, Mr. Bryce. How are you?
Good. Up until this point, I haven't been able to actually show the board I'm wearing a tie, but I usually sit here wearing a tie, but now I get video, so people can know that I'm actually properly attired. But I represent the Friends of Green Space, and I do have a few questions for you. The first question that I want to ask you is just about being a planner. And in that regard, isn't it typical as a professional planner in the state of New Jersey that you derive opinions that are based not only upon the municipal land use law, but also relevant case law?
Yes, no doubt about it. We operate within a legal framework.
Okay. So as a professional planner, although it may be a mixed question of opinion, it is typical that you will render opinions that have a legal undertone or overtone to them, correct?
Yes.
Okay. So if I ask you questions regarding relevant case law, that's fair game, correct?
Well, put it this way, I'll do my best.
Fair enough. If I ask you questions about the municipal land use law, you'd be competent to testify as to that as well, correct?
I hope so.
Okay. And also as to general planning and site plan variance applications and how those are processed as well, the general procedures, correct?
Yes.
Now, earlier you testified that this particular property is located in the R1 zone district, correct?
Right. The front piece is in the R3.
And aside from that's fair. Aside from the agricultural or horticultural purposes that you previously mentioned, there's no other real permitted use in that zone except for single-family dwellings, correct?
Well, interestingly, a senior center could go here as well. Public community center building, public library, public buildings can go here. Places of public assembly are permitted here. It says public community center, but that could very well be a senior center.
I should be a little bit more specific as far as residential uses are concerned. The only
Single
residential
family.
use.
Yes, single family detached dwelling, and then I think in all residential districts, community residences for the developmentally disabled by statute are permitted as well.
That's fair. You'd agree that the subject property as it's currently utilized is a conditional use within the zone district, correct?
Could you say that again, Mr. Bryce? I'm sorry.
The subject property, and by that I mean the totality of the property, is currently utilized as a church, correct?
Correct.
And that is a conditional use within the zone district, correct?
I'm trying to, I'll give you that it is. I'm trying to remember, but yeah, I think in my report I said it's a permitted use, but I'll give you conditional use.
Okay. And the bulk requirements that are applicable to the R1 zone district are generally designed for single-family homes, correct?
Yes.
So it's fair to say that the proposed development for this section of the subject property, and by subject property, I'm just going to refer to the subject property as the Thrive parcel.
Okay.
As far as that development for the subject property is concerned, there's no bulk requirements that they're able to comply with by way of the underlying zoning, correct?
Well, I'm seeing that there is, I have to go back to Mr. Textoris's plan, but I don't think there was bulk variances. Just double check. Coverage. I see an asterisk by coverage.
So just as far as coverage is concerned, I believe that in the R1 zone district, there's a permitted coverage of 20% for single-family dwellings, correct?
I'll give you that. Yeah, I'd have to look up the zone. I'm looking at the zoning chart here, which says 65%, but
Okay.
yeah,
With that
there's
65, that leads me to my next question. That 65% coverage limitation, is that applicable to the conditional use?
Okay, I see now. Yeah, so there's the nesting that takes you back to 430-41, which I see where you're going. Yes, that would be applicable to the conditional use. Yes.
And that's not necessarily applicable to any other use except for a conditional use, correct?
Correct.
And do you know what the proposed impervious coverage is for this particular site?
Again, I'm referring to the overall variance plan here, and it is showing 60% plus in terms of the proposed lot.
Okay. Now, it's non-definitive, you'd agree with me, right? It just says 60% plus.
Yes.
It's not definitive as to what the actual impervious coverage is.
It's not precise.
It could be in excess of 65% as far as you know.
Well, it says what it says. It's 60% plus. It doesn't say 60. It doesn't say 60. It doesn't say it's over 65%. And I'm not seeing an indication of anticipated relief.
Right. When you're looking at that site plan, would you agree to me, or I should say, let me strike that. When you're looking at the variance plan, just based upon the bulking of the proposed impervious coverage and the actual structures that are proposed, does it look like it could be more than 65% impervious coverage?
I'm looking at the architectural plan and I'm seeing a lot of green. So I'm going to say it will be calculated, but there's a lot of green on this architectural plan. So it could be 40% of this architectural plan is green.
I'm not talking about the architectural plan. I'm talking about the variance plan. When you look at that,
Well, yeah, they're one in the same. The architectural site plan and the variance plan that the engineer put together are one in the same. From a layout
but
perspective.
I'll make it simple. You don't know what the actual impervious coverage is, and it could very well be over 65%.
That's correct. And that would be a variance that would come out during site plan.
Okay, and that shouldn't be considered in the overall scheme of a D variance looking for negative impacts?
I don't think so here because there's not an indication unless there's a misrepresentation that's deliberate. When it says 60% plus, it is not saying 65%. There is not an indication here that relief is anticipated. It could be, and that could be a consideration as part of site plan. But I don't think it is so far-fetched to think that the coverage would be more than that to impact the use relief that the applicant is seeking here now.
Okay. The only thing that the variance plan actually indicates is that it's over 60%. We don't know to what degree over 60%. Correct?
That's a fact.
Okay. And in your experience as a planner, looking at projects that require D variances, does impervious coverage that greatly exceeds what is otherwise permitted in the zone district ever factor in to whether or not you are weighing negative impacts of development?
Yes.
Now, you'd agree with me that based upon the zoning ordinance, and I think that you testified as to this, assisted living facilities are not permitted within this zone district, correct?
Correct.
Would you agree with me that multifamily high-density housing is not permitted within the zone district?
Correct.
That would include townhomes, attached or detached, correct?
I would have to go back and look at, Parsippany has zoned for a lot of affordable housing sites, and there are overlays over districts where multifamily is allowed, again, for a specific public purpose, which this has a nexus with as well. And I just don't know. I'd have to go back and check to see if any of those affordable housing sites were overlaid on R1 sites.
Okay.
I just don't know.
I'll represent to you based upon the township's planner, Burgess, I guess it's their consulting planner, from a memo dated June 25th, 2020, that their inclusionary development sites include the Stanberry site, which is certainly not within this zone district, the McCallie sites, which is not within this zone district, the Westmont Plaza site, not within the zone district, the 750 Edwards Road LLC site, not within the zone district, 887 Edwards Road site, also not within this zone district. The Wykert site, also not within the zone district. The SJPMC 6 site, not within the zone district. Based upon that representation, do you have any reason not to believe that that's the current overlay zones that are affected? There are some overlay zones, strike that. We have overlay zone districts at North Beverwick Road, Era and North Beverwick Road, Landex, Continental Road, Mount Arlington Center site, and the GlaxoSmithKline site, which we're going to talk about. Based upon those representations, you don't believe that there's any type of multifamily allowed in an affordable overlay in this township for this zone, is there?
I don't know. I do know 2025 is coming. We'll see where the next round goes.
Okay. But ultimately, the reason why you're before this board is that you're seeking a D variance, which is a use variance to do something that you're not otherwise permitted to do within the R1 zone district, right?
That is correct. An important part of the planning consideration in the Sika test, we don't necessarily have to reconcile the zone with the zone plan. It's not an aspect of the Sika test.
Well, we're going to talk, believe me, Mr. McDonough, we are going to get there, I promise.
Thank you.
But just to be clear, and you were present when for the virtual hearings, virtually present for the testimony of Mr. Stretch and for the site engineer and for the traffic engineer as well, correct?
Correct.
Okay. You've heard all of their testimony, and actually you adopted their testimony basically by reference tonight. Is that fair?
Right. Yes.
Now, as conceded by the applicant's engineer, you would agree that the subject property could be developed for single-family development, correct?
Physically, yes.
And it would yield single-family homes.
Yes.
And I believe it was indicated that it's both it's physically feasible and possible to do that within the zone district and the way that this property is laid out.
Yes.
Now, just talking about this site relative to the township, I believe you testified that assisted living facilities are permitted uses within other parts of the township, correct?
Yes. I think I ran off 3 zone districts.
Well, I think you might have missed one. Would you agree that they're permitted in the OVL 6 zone district?
I have OVL written down. I have COD and then the OS.
Okay, how about the FO district?
I didn't review all the zone districts where the use could go. I don't think it's relevant to the analysis.
Okay, so but there are other properties and other zones where assisted living in this township can be placed, correct?
That's correct.
But because you did testify about needs and you related that to an old master plan review, correct?
A 2014 re-exam, which has not been contradicted in the new 2020 re-exam.
Well, we'll talk about that too. But nonetheless, you did touch upon, that there's a need for this. But I do want you to acknowledge that the township is creating areas where assisted living facilities can be developed, correct?
There are zones designated for assisted living, yes.
And in fact, you testified about Care One.
Yes.
That you were involved with.
Yes.
Now we're going to talk a little bit more about Care One in the near future, but Care One does exist at this point, and it does provide assisted living, correct?
Certainly does.
within the general geographic area, do you know how many assisted living facilities there are?
No,
Would it surprise you to say that, within a 10-mile radius, there's 1, 2, 3, 4, 5, 6 at least assisted livings with varying level of cares?
it's not enough.
And okay, fair enough. You think the township ought to do more, right? Are you
Yes.
Are you familiar with a property located at 1500 Littleton Road?
Could you say the address again?
1500 Littleton Road.
I need more specificity. The address is not jumping out at me.
It's the old GlaxoSmithKline property. Are you familiar with that?
I don't remember which, is that in Mac Cali? I didn't work on that site.
You should be surprised that that's being developed for assisted living.
I was not aware.
Now, just going back, talking about the master plan, is it fair to say that the 2019 master plan, although that wasn't referenced in your report, actually recognizes these types of assisted living developments?
Yes, and just a point of clarification, I wrote my report in 2019 and the master plan, the new master plan was adopted in 2020, after I wrote the report. So my references are all to 2014.
Did you have an opportunity to update your report?
I didn't update the report because I didn't see anything in the new master plan that contradicted the findings of the 2014 master plan.
Well, we'll talk about the master plan in a second, but you do concede that the master plan itself does identify where these particular types of developments are assigned from a master plan perspective and a planning perspective within the township, correct?
Right, there's language in there about the need to plan for this land use in appropriate locations.
Okay. And in fact, would you agree that the township, by way of its governing body and their authority, has actually effectuated that through the adoption of ordinances that allow for these uses in the zone districts as called for by the master plan that the planning board actually reviewed and adopted?
It's a factual statement, but it doesn't, good planning doesn't stop there. When we zone, we paint with a broad brush, and sites have been selected. But when the governing body and the planning board considered other sites, they did not have the level of detail that this board has, which is exactly why we have zoning boards. It's site specific.
Are you familiar with case law that very much says it is the preference to zone through ordinance rather than by variance?
That's an overly broad statement. The Medici case goes back to 1987. What is that, 40, 50 years now? The D variance, the use variance mechanism has not been taken away. That's why we have this board to go through this vetting.
But the court does recognize that it is better to zone through ordinances than through variance, correct?
That's where the process starts. And again, what came out of Medici was the same variance being approved over and over again with all of those hotels out in South Plainfield. This is the first one.
The Medici case is still good law, correct?
Yes.
As a planner, you still rely upon it, don't you?
Supreme Court. I've worked on the site.
So when the court says that it's better to zone through ordinance than variance, that still has some weight, doesn't it?
It has weight, but again, the essence of that case was approving the same land use over and over by variance. The court said that's not the way we're supposed to do it. Eventually, you're supposed to rezone.
Okay. And the zoning ordinance, in order to be valid, has to be, as a planner, wouldn't you agree that in order for a zoning ordinance to be valid, it has to be consistent with the master plan? And if it's not, there has to be special reasons adopted by the governing body why it wouldn't be, correct?
Unless we're dealing with an inherently beneficial use. And the
And we're going to
special
get to
reason,
that. But generally, under the Riggs test for ordinance validity, it has to have some bearing to the master plan, correct?
yes, Riggs was the case that essentially married the master plan with the zoning ordinance, yes.
So in the township of Parsippany's current situation, would you agree that you have now a 2020 master plan that calls out specific uses such as assisted living, recognizes where generally they ought to be placed, and the governing body has adopted ordinances consistent with that master plan?
Yes, that's a factual statement. Again, I think we have a novel approach here, which I think is a creative one. It's actually a purpose of zoning, purpose P, to provide for creative use of land. One of the newer purposes of zoning. And you heard through our operator, integration is the key to this. We don't want to put this land use off in the office parks. We want to integrate it with residential neighborhoods. I think the board can give deference to that.
Okay. Should the board also give deference, in your opinion, to what the planning board said through its master plan and what the governing body said through its zoning ordinance? Or should they just rely upon what your operator says?
Maybe they didn't have the benefit of the industry information that our operator is playing off of. This is reflective of the trend. We
Mr.
don't want
McDonough,
this.
You testified that when you prepared your report, you did it in 2019 before the benefit of the new master plan, correct?
Correct.
That new master plan was undertaken. They actually looked. It's not just a master plan review. It is a master plan. And they looked at the R1 zone district, did they not?
They did.
They actually looked at this specific area of the township, did they not?
They did.
Did they make any recommendation in the master plan that the R1 zone district should in any way encompass high-density housing, whether it be senior, age-restricted, or otherwise?
No, it did not have the level of detail that this lower intensity land use has.
Okay. You're not saying that this land use is a lower intensity than single-family dwellings, are you?
I'm saying based on the traffic testimony, based on the engineering testimony that has gone before me, that this level of intensity on this site will not exceed the carrying capacity of the land.
This is jumping ahead from where I wanted to go, but you bring up traffic. Do you recall that the traffic engineer conceded that this particular use will generate more traffic than the single family dwelling development that's potentially viable there?
It's not the test of whether it generates more traffic or not. But he did say that, yes.
And I think that he did conclude that there will be a negative traffic impact because of this, correct?
He concluded that the project with the improvements proposed will be a net positive.
And I'll let the record speak for itself as to that. I think that the board remembers that, and I recall that testimony very well. And I just frankly find it to be a little bit different than yours, but that's okay. Let's just get back to the SECA test, because you indicated to Mr. Chadwick, you believe that this entire development is subject to the Sika test because it's inherently beneficial, correct?
Correct.
Okay. And under the Sika test, you explain that there are 4 elements: the public interest at stake, the detrimental impacts, reasonable conditions or accommodations to mitigate it, and then the board's required to weigh those positives and negatives, correct?
It's a balancing test. It's a balancing test that starts with heavy weight on the positive side.
Now, just before we get into that test, just some general questions about your understanding of the D-variance criteria. And I'm going to just cite right from the statute, and I think that it's an important thing to state also for the benefit of the public. You would agree that under Section 70 of the Municipal Land Use Law, especially as related to D-variances, that the law itself says no variance or other relief may be granted under the terms of this section, including a variance or other relief involving an inherently beneficial use, without showing that such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and the purpose of the zone plan and zoning ordinance. That's
You
correct.
read well. You read well. That goes towards what I said, that this land use doesn't get a free pass.
Okay, so under the negative criteria, it's actually 3 things that we have to look at under the negative criteria, which is substantial detriment to the public good, and also the impairment of the intent and the purpose of both the zone plan and the zoning ordinance.
Yes.
Correct? Okay.
Yes.
You agree that in satisfying that negative criteria, regardless of an inherently beneficial use as you purport this is, it is the applicant's burden to demonstrate that and satisfy the negative criteria.
Yes. It's what the applicant's been doing for 5 hearings.
And do you agree that as a general principle, that under existing case law that is well cited, that D variances generally only should be granted sparingly and with great caution, quote unquote?
Variances should be granted when the statutory test is met based on the evidence on the record.
But nonetheless, you would agree with me that the courts do say they should be granted sparingly and with great caution.
That's language in a case, I guess. I don't know which case it is, but that said, again, we have unwavering expert testimony that there will be no substantially adverse impacts. Uncontroverted.
That's fine. Hold on a second. I can find this. This is kind of an aside. There was some discussion, and this is a little bit out of order of my line of questioning, but there was some discussion about the affordable housing set aside. You would agree with me that simply because there's a required, affordable housing set aside, that in of itself is not a criteria or a positive criteria for a D variance?
No, I think the provision of affordable housing, yes, the affordable housing component is inherently beneficial.
Okay. Are you aware of the case of Advance of Branchburg 2 versus Township of Branchburg? It's 433 NJ Super 247. It's an appellate division case from 2013. Are you
Yes.
familiar with that case at all? Are you
Yes.
familiar with the fact that the appellate division specifically held that inclusion of affordable housing units in a development does not transform it into an inherently beneficial use?
There's that case, but there's contradictory case law out there as well.
And are those contradictory case laws for developments that are 100% affordable housing?
Again, my understanding of the law, I'm trying to remember if it was that the Homes of Hope case talked about the aspect of the affordable component of a inclusionary project is inherently beneficial. So I think there's contradictory law out there.
Okay. So you did testify that it's your entire opinion that this entire project is inherently beneficial. Notably, you indicate that a lot of that opinion comes from your experience with Care One. You did testify.
Yes.
Okay. Now, in testifying about Care One, you may have conflated a few things because you did testify that Care One similarly had assisted living, which I'll concede is an inherently beneficial component. But you also then stated that Care One has independent living. Do you recall that?
Yes.
I'm looking at the Care One Parsippany website, and their services include long-term care, subacute rehabilitation, cardiac care management, complex medical, diabetes, elder care, long-term care, and medical subsidization specializations, orthopedic rehabilitation, pulmonary rehabilitation, respite care, stroke recovery, subacute rehab, and wound care management. Parsippany specifically does not indicate in any way, shape, or form any type of independent living. And frankly, I unfortunately also had occasions to use a Care One facility, and I'm not familiar with any independent living at Care One. So are you certain that Care One actually has an individual independent living component?
My notes in my testimony talked about independent living and assisted living. These are my notes. I'm going back to my testimony. Now, this was 2005.
Okay.
It may have changed. They may have gone all assisted. I don't know.
Well, I can just represent that it does not appear that any Care One facility that I've been to, or certainly that I can reference via the internet at this short date, indicates any type of independent living component. And I guess regardless of not having an independent component, you'd still say that this proposal for Thrive in totality is still an inherently beneficial use, right?
Yes, it's all one package. It's one thing.
Your report, in fact, as support of that, does it in a footnote. Would you agree?
My report cited in the footnote, I think 3 or 4 cases that I've run into before in terms of inherently beneficial for this land use.
Okay. You know, let's talk about those cases because I'm looking at the Sunrise v. Zoning Board of Adjustment of Madison Township. Were you personally involved in that case?
I was not.
Utilizing, and this is going to come out very inarticulate and I apologize, but utilizing Westlaw, which is a well-accepted database that we subscribe to, I can only find one citation to that where the Supreme Court remanded it back to the planning board, or the zoning board, excuse me, as a conditional use application because of a zone change. I can't find any other underlying opinion as to the Sunrise Inc. v. Zoning Board of Adjustment of Madison Township. And I note in your report, you don't have a citation there. So I'm curious, what is your understanding, and where do you come up with your understanding of the Sunrise Inc. v. Zoning Board of Adjustment of Township of Madison without a citation and without any type of ability for myself or anybody in the public to actually look at to see what a court said?
I don't remember, honestly. I don't remember. This may have been fed to me by an attorney. I don't remember.
Is it typically your job as an expert witness that is a professional planner to not do independent research and just rely upon what's fed to you by an attorney?
Well, again, when it comes to the law, I'm not going to overrule an attorney.
But you did testify that as a professional planner, you do rely on law, correct?
I do, and I didn't
Okay.
drill down on the fact pattern of any of these.
Okay, so in your report, you cite something in your report that you drafted that you don't really know anything about.
Objection. I've held my tongue and I'll keep my tongue. He's arguing what the meaning of sunrise is. And because counsel takes the position that sunrise stands for something which, quite frankly, I disagree with, and I'm sure if Mr. King read the decision, he'd disagree with counsel. And we're not going to sit here, and I think it's appropriate to argue what the meaning of sunrise is. The meaning that is ascribed to by Mr. Bryce is not correct. I state that as a fact. He may have a different opinion. We can argue what sunrise means at some other point, but to waste the time of this board to keep questioning a planning witness as to the meaning of sunrise gets us nowhere.
You know what, Mr. Vogel, I couldn't agree more. That is not the purpose of my line of questioning. The purpose of my line of questioning is to establish the fact that we have an expert report that was submitted by your expert, who cited in his report, and I believe it's completely within the scope of proper cross-examination.
Quite frankly, Mr. Bryce, I think he's
upon which he states that.
You know,
May I please
just
finish,
a moment.
Hey, counsel,
I'll leave this to the chairman to decide. Let the chairman decide. My position is that he's correctly quoted sunrise. You believe he didn't.
Counsel, the case stands for what the case stands for. It can be interpreted different ways, and you know, the objector's counsel can ask questions about what he believes it is, but at the end of the day, the case stands for what it stands for. The court has made certain findings and facts, and each party can argue those facts.
And Mr. King, I couldn't agree more. The point is that we have an expert that in his expert report did cite a case, and that expert, and I'm exploring.
But Mr. Bryce, the expert explained what he thought it meant to him and how he interprets that to his expert opinion. And we all know that that's fair game in any type of appeal or any decision that could come from it. But I think he's explained, you know, how he relied on that or what he thinks that is. And depending on what occurs here at a next level, if there is a next level, that could be an argument to be made in briefs and submissions to a review in court.
Well, let me continue that line of questioning. You do cite, Mr. McDonough, the Sunrise Inc. v. Zoning Board of Adjustment of Madison Township case, correct?
Right here in the footnote, yes.
Did you read that case?
No.
Do you have any impression upon what that case means?
Again, I know the facility over in Madison, but these three cases that I put in here are the cases that I commonly come across where I haven't seen it questioned yet, that these are the benchmark cases that determine this land use is inherently beneficial.
Okay, well, I want to stick on the Sunrise case because you, sir, have stated in your direct testimony that you cited these cases to say it's clearly an inherently beneficial use. And then I get to the Sunrise case and you say you haven't even read the case.
I have not read the case. I often read Cox, and
Is
look the
it
cases.
in Cox? Is it in Cox?
I don't know.
Okay. You have no idea about what the Sunrise case is, do you?
I don't.
Okay. Thank you. Now let's talk about the Borough of Roselle Park case, the Township of Union. Did you read that case?
No.
Okay. Would you be surprised that the majority of that case discusses standing for one municipality to challenge a zoning determination of another municipality?
Okay.
Do you know what the senior housing was at issue in that case?
No.
Would it surprise you that the senior housing was for public senior housing in that case?
Objection. The law makes no difference between public or private housing. It's
Oh,
very
yes, it
clear,
does.
and
Well,
Mr. Bryce should
yes,
know
it
that.
does.
If he's read these
I'm
cases
confident.
and he's
I
read
have a
the law,
question to the
he'd be
witness.
available.
I have a question to the witness, and it's a valid question.
And I answered.
And you also cite the Reese Street Jared House v. Patterson at 249 NJ Super 205 in 1991. Did you read that case?
No. Again, I've run into these cases before as the benchmark cases as to why this land use is inherently beneficial. I did not drill down on the fact pattern.
Okay. But you rely on the fact pattern to make a representation to this board that this entire application with components of not only, which I will stipulate, has inherently beneficial uses of assisted living and memory care, to also include independent living as an inherently beneficial use.
Well, that is the law and the cases so hold. And if you want to come up with cases that are adverse to it, come up. But don't question this witness about if he read a particular case when you should know that the law is very clear that any facility that contains those particular uses, including independent living, have been constantly and continually held to be inherently beneficial.
Well, Mr. Vogel, maybe I'll cross-examine you because I'm going to dare you to find a case. Let me continue with my examination of the witness, please. Would you be surprised that in the Reese Street case, that case dealt with a nonprofit housing project for low-income seniors?
Okay.
That is what they considered to be inherently beneficial uses, correct? In those cases, although I guess you didn't read them, so I'll withdraw the question. So my next question is, are you familiar as a planner sitting here today with any statute or case that holds simple old age-restricted housing is an inherently beneficial use?
Again, I put these three cases in here, which based on my experience are the cases that planners point to. Just like we would point to Medici as a use variance without knowing all the fact patterns of that particular case.
Do any of those cases consider an independent age-restricted use, an age-restricted independent living to be an inherently beneficial use?
Again, I don't know. I have never drilled down on that aspect of these cases. It's a legal brief to me. It sounds like it's a legal argument.
So, but you do, as a planner, consider legal arguments and legal ideas that weigh in on planning, correct?
Right. We're guided by law as to which statutory test applies, And when we're dealing with assisted living, senior living, these are the cases that are commonly referred to in terms of pointing towards the Sika test.
Okay. Now, as an applicant for even an inherently beneficial use, do you agree that if somebody is purporting to come forward with a non-statutorily defined inherently beneficial use, it is their burden and obligation to demonstrate the inherently beneficial use being advanced?
I don't follow the question. No, I don't agree with that statement.
Okay, let me ask you this, is it the objector's job to establish that an inherently beneficial use is not inherently beneficial? Or is it the applicant's job to state and prove that what they purport is an inherently beneficial use is in fact an inherently beneficial use?
Objection, that's not a planning statement. What counsel's attempting to do is to make this witness a legal witness and not a planning witness. This, I defer to Mr. King and to the chairman. This is a question about the interpretation of the law and is not a planning question.
Yeah, I don't disagree with you. I think the question was who has the burden of proof. We all know that it's the applicant's burden of proof.
Okay, I'll take that, Mr. King. You did hear Mr. McDonough, Les Stretch testify, correct?
At 2 hearings.
Did you ever hear Mr. Stretch testify as to a specific minimum age requirement for this particular use?
No, this is an age-targeted development. And his reaction to the question of a 45-year-old coming here was that's far-fetched. He's never heard of that. He's never
Okay.
encountered that. It's age-targeted. It's targeted for an older population based on the programs, the physical plant. This is not targeted for younger adults.
I understand where it's targeted for. I just asked you if he testified as to the age. I guess the
He
answer
did
is
give
no.
you, he did give you ages of each one of the components,
Okay.
different
Okay.
housing modules that he has here.
So would you agree with me that he also testified that as far as the independent living cottages, we open quote, we typically don't write age into the leases as they are not licensed product?
Agreed.
So there really is no, as far as you're concerned, or have knowledge of, there is no age limitation aside from a target or audience for this particular application, right?
If that is a major issue to this board, they can impose a reasonable condition on age.
Okay. Now, going through your report, and I'm just going to highlight the public interest at stake. In evaluating a purported inherently beneficial use, is it accepted that the magnitude of what's at stake has to be considered?
Yes,
And in this report, you do testify or you do cite the 2014 Master Plan Reexamination Report, correct?
correct.
And we do know that there was subsequently adopted in 2020, the Township of Troy Hills Master Plan, correct?
Correct.
You indicated that in your testimony that continued, that particular 2021 continued demographically consistently with the age cohort of 55 and older being the majority of the population, I think is what you said.
There's a statement in the master plan, recognition, yes, that the population is aging.
In the master plan at figure 1, they indicate that 65 plus is 16% and 55 to 64 is 14%, correct?
You say those numbers again. I'm looking at, your figure one is 65 plus is 16%, 55, 64 is 14%.
Okay, and those two combined are about 30%. They're not the majority of
That's-
the two, right?
Yes.
Now, just getting through, you know, and just continuing down the Seca line. Um, in looking at the negative criteria and what the Seca test even imposes, but even the statutory negative criteria. One of the criteria, or two of the criteria, says number one, it can't substantially impair the purpose of the zone plan. And it also says the zoning ordinance, correct?
Correct.
The application for this particular use would run directly foul of the zoning ordinance, correct?
I don't think the degree of departure is substantial. No, it's a residential use in a residential area. It's a different building type, no doubt about it.
And would that be informed through the master plan, which actually outlines what the zone plan is?
That's right. That's the underlying policy statement for what is the law, the zoning ordinance.
Okay, let's talk about the master plan then. I'm gonna say to you, did you look at goal one of the master plan?
Yes.
And what does goal one of the master plan say?
Basically, to protect the integrity of residential neighborhoods.
Let's be specific. It says to preserve and protect the character, density, and aesthetics of the township's established and stable residential neighborhoods by restricting incompatible land uses from these areas and significant increases in intensities of use, correct?
Yes.
Does this particular application that you have, in your opinion, meet goal number one of the master plan?
It's not going, this residential development is not reliant upon Reader Drive for access, and it's not tapping into the neighborhood to the north as well. This is certainly maintaining the integrity of those neighborhoods. Those neighborhoods are not reliant upon this patch of land as a park. If they are, it's trespass. No, that neighborhood is not reliant upon a piece of property that doesn't belong to the neighborhood.
Okay, so you don't believe that putting this particular development in between those two residential neighborhoods would impact the character of those neighborhoods?
Would not impact the character at all. The applicant has put together a land use that integrates well within the landform and provides good green space around the perimeter of the property. So the answer is absolutely yes. Institutional use is there right now. If that were to work its way up the hill, that could be considered as contemplation of the zone scheme as well in terms of the impact on the neighborhood. And the zone plan says that's okay.
But Mr. McDonough, you'd agree with me that that's a conditional use that's otherwise permitted in the zone, right?
But we always have to consider what the zone plan says is okay from an intensity and from a physical planning standpoint.
Do you think that do you think that the proposed project would influence the density in that zone district?
What I'm telling you is that you have two distinct neighborhoods that flank this particular piece of property. If density is being added to the middle of those two particular neighborhoods, the impact is not going to be substantially adverse by virtue of the fact that we're not dropping this in the middle of those neighborhoods. We're at the edge of both of those neighborhoods.
Okay. Well, I'll tell you what, let's resolve this by looking at the policy statement that accompanies that goal. Let's see if that sheds light on it. It says the Township of Parsippany Troy Hills recognizes that one of its most important attributes to its residential neighborhoods with limited intrusions of non-residential development or inappropriately scaled residential development within those neighborhoods. The plan's land use recommendations are designed to protect and reinforce the prevailing residential development patterns, prevent incompatible land use arrangements, and reinforce the intensities of use recommended in this plan, while ensuring that the township residents have the ability to enhance their properties and adapt to modern preferences. So with that policy, do you think that this is an intrusion of an inappropriately scaled residential development?
It's absolutely not an intrusion in those residential neighborhoods. Rita Drive is its own independent neighborhood, independent of Dolly Drive. The two don't interconnect. They're their own separate neighborhoods, and we're at the edge, and we've maintained separation from those. We are our own neighborhood.
Let me ask you this, is your proposed project in goal number 1 in its policy reinforcing the prevailing residential development pattern of those neighborhoods?
We are not dropping this in the middle of those neighborhoods. We are dropping them on the edge of those neighborhoods.
How about goal number 2? Goal number 2 says to provide a variety of housing types, densities, and a balanced housing supply in appropriate locations to serve township residents of various ages, household types, and incomes. You'd agree with that, right?
You're reading well.
Okay. I'm going to read policy statement, and it says, at the same time, the development of new townhomes, of a new townhouse or apartment unit should be directed toward established centers of development in close proximity to transit and business corridors, and should be planned to mitigate potential impacts, including on established single-family neighborhoods, traffic, infrastructure, environmental resources, light, air, open space, and the integrity of the land use plan. I assume that you would find that your proposed application meets that policy.
It does. One of the nice things about this area, having lived it, is the diversity of the area. The school has a major influence in the area. There's no doubt about that with what goes up and down Rita Drive. The church, what happens on the weekend. All of these uses commingle. You're painting a picture that this is a pure single-family neighborhood. It's not. There's a lot of different things happening there. This integrates very well with that diversity, which is exactly what that goal number 2 says. It's exactly what it says.
Aside from the conditional use of the church and the school, where is the next closest high-density housing development to those particular neighborhoods?
What's the purpose of that question? I'm sorry. I'm getting really confused here on this testimony, Mr. Bryce. I'm sorry. What's the consequence you want the board to hear the answer to that question?
Mr. Willens, the consequence is this. The master plan sets out very clear.
We understand all that. Got it.
And the witness is saying that this particular proposal is completely consistent with the master plan policies. And I'm asking, where's the next high density neighborhood in this development pattern that not only the master plan sets forward, but the township ordinances?
So if you would like the board to consider the fact that this application is in direct conflict with the meaning and construction of the master plan. Is that correct?
I think that the board has to, pursuant to the negative criteria of the statute.
Thank you very much. That's your point of questioning. Thank you.
And my response to that is you're not painting an accurate picture of that area at all. Littleton Road is dotted with a mix of different uses. It is not a pure residential neighborhood. That's why it works over there. You have this nice mix of uses. It's a perfect spot to commingle with all of that diversity that's happening over. You got Brooklawn on the other side of Littleton right there. You've got medical uses, you've got home occupation conversions all along Littleton. This is not house upon house upon house. Those homes on Rita Drive and the neighborhood to the north all commingle with all these different things. They drive in and out of those areas every single day. It's diversified, that area. It's not homogeneous.
And that's your testimony. That's your opinion. That's fine.
That is a land use planning fact.
I don't know if it's factually accurate, but hey, that's your opinion. I'll go with it.
Can I just interject a moment here? It is 9:52. We normally go to 10 o'clock. I mean, I would do a little leeway, but the way your cross-examination is going, Mr. Bryce, I may have another birthday before you're done. So I think I would ask Nora to start looking at her book. Mr. Bryce, you got to step it up, baby. You know, you're a sure cure for insomnia. Let me tell you. Okay.
I got to get it on the record, Chairman.
Look, I understand what you can ask all the questions you want, but you got to step it up. Okay. This is a very, very busy board, and I am not going to authorize any more special meetings. So, and that's at the expense of the applicant, which I am not happy about. So Nora, what's our next meeting?
June 22nd.
What was the date? I'm sorry, Nora.
June 22nd.
What
That's a
happened
full night, right?
what happened to April and May?
They're packed.
We have a busy board. Are we still doing 7 o'clock meetings for residentials, Nora, or have we
Yes.
passed? So, Mr. Vogel, this unfortunately, you know, a couple of years of the government shutting down has put tremendous burden on us, and you know, we're paying the piper now. We go for 2.5 hours. You know, I'd like to, you know, do an extra 15 or 20 minutes, but Mr. Bryce is not going to finish in 15 or 20 minutes, I'm sure.
Why don't we ask him? Why don't we ask Mr. Bryce if maybe he can finish by 10:15 or so, or just, it's worth the questions.
Okay, let's ask the question.
It depends on, to be honest with you, it depends on the answers I get and the objections that I receive. But
Well, how many more questions do you have to ask?
I have, well, it depends. It depends on the answers, Chairman. It's cross-examination. I have a bunch of stuff to go through the master plan with. It may be boring, but it's-
Mr. Bryce, how many more questions do you think you have? You know, 20, 30?
Probably about 30 is fair.
30 questions. Okay. June 22nd, Mr. Vogel, is that okay? Mr. McDonough?
Sure. Yeah, I hear it.
And unfortunately, I think we're going to have to continue with these virtual meetings because we do not have a facility to house an in-person meeting. Somebody said, "Oh, why don't we go to a school?" I really don't. I mean, I'm not even about to approach the Board of Education because I know what the answer will be. They're not going to let us in. Not,
And I think, Mr. Chairman, I think their COVID requirements are even more stringent than the municipal requirements.
Yeah, sure. I mean, with the kids and everything, you know, it's so.
Just so you know, the COVID requirements in schools have been dropped. They're the
Been
same
dropped?
as the municipalities.
Okay, so Nora, why don't you broach the subject with the Board of Education and see if we could get an auditorium to have an in-person meeting? Well, Mr. Kaplan knows he's in that profession, so
Yeah, look, I think it's a fair ask, and if they say no, then we're stuck. But if at least we ask the question, I think that's our due diligence.
I fully agree, Mr. Kaplan. I was not aware that things had loosened up that much. I mean,
It's quite wonderful again, Mr. Chair.
well, I see clients every day now for the first time in 2 years, and I still have half of the people coming to see me are wearing masks. So it just, I guess we go with the flow.
Mr.
There's
Chairman,
a
just to that point though, quite frankly, this format to me, for this particular topic, what's the benefit of an in-person meeting for all of us have to come out to spend 3 or 4 hours in an auditorium listening to this oration of cross-examination? I'm sorry.
It's not for us, Davey. It's for the public.
Okay,
Could
I
I-
understand. They're here, so they can listen. Anyway.
Could I just follow up on Mr. Williams' statement that there's there's a legal problem. We have to announce at tonight's meeting that the meeting is continued to June 22. And we have to announce where the meeting is going to be held. And if you don't have the time and place to make the announcement, you would have to send notices out again. So I would suggest to the board.
I don't disagree with you, Mr. Vogel, but what we could do is we could carry this case to the next meeting for further announcement. But I say, let's go with the next one, virtual. And then that gives us a couple of months to figure out what's going on. By then, the school will be closed for the summer and we might be able to work something out.
I think June 22nd is graduation.
Oh, okay, so we're not gonna be in a school that night anyway. Motion to carry this case to June 22nd without further notice, and it will be a virtual meeting on the WebEx.
So moved.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Anyone opposed? Okay. I thank everyone for their consideration and time and effort. And we'll see everyone on June 22nd. It will be the whole night, except for our resolutions at the beginning. We will give you another whole night and hopefully we can conclude. Okay?
Are we having another meeting? Are we having another meeting now?
Are we having another meeting now?
Yeah, that Peter's letter.
Peter? Do we have to?
We have time. We can carry it to the next meeting. You all have the letter.
Okay.
So
We're going to close this one anyway, right?
it's a late night, so we can carry
Okay.
it to next meeting.
That's fine. Okay.
Just what it is.
Motion to adjourn?
So moved.
Second, Snyder.
All in favor?
Aye.
Anyone opposed? Okay, once again, I thank everyone for their help and time. Signing off.
Thank you, everyone.
Good night.
Aye.
Have a nice day.
Good night.
Nice night. See you, John.